Hello, everyone. It's a pleasure to join you today, and thank you, Etienne, for the introduction. My name is Morshed, and I am now a longtime member of COALA. I became involved with COALA when I was doing my PhD research at Leiden University at their law school in corporate law. And at that time, I became very interested in DAOs in particular, and they had just sort of, at that time, only really started being discussed widely as a concept. And in fact, one of the first things I wrote about DAOs was about colony. I'm very happy to talk about that at some other time as well. But basically, in this early process, I got to know Primavera de Filippi and some others at COALA, and became involved in both academic work with them, but also drafting this model law. And I'll tell you a bit more about why such a model law is necessary and why it's starting to gain some attention. As I already alluded to, I have a background in legal academia. I worked as a lawyer for a while, being dual qualified in England and in Bangladesh, where I'm from. At present, I am still in academia. After having finished my PhD, I took on a role as a postdoctoral research fellow at the European University Institute in Florence, Italy, where I continue to do research on blockchain governance and regulation with Primavera and some others. And that's sort of the gist of my background. What I'd like to do today is explain a bit more about some of the pain points that we see with DAOs and why we think a model law was necessary as far back as 2018, when we started exploring the possibility of a model law. So the first pain point that we thought was very important to discuss was the issue of legal personality. So if a DAO is not something that only interacts with other DAOs, or only does not try to aspire to be something that only has on-chain activities, then there is a need to be able to interface with the off-chain legal system, the off-chain like commercial world, society, and so on. And legal personality has a very important function there. For lawyers, we see it as being an important way through which an organization is able to, for instance, enter into contracts with another entity. And without it, the issue arises that then the people behind it become the person who is the contracting counterparty. And that, again, is difficult in this context, both practically speaking, but also potentially normatively, because if one of the attributes of a DAO is to preserve pseudonymity, then again you don't want to have to force people to divulge what their identity is, but also there's this benefit of allowing the entity itself to be able to enter into contracts, to sue in its own name, and so on. So that was something that, from quite an early stage, we started noticing that this was something that was needed, a way of trying to gain legal personality. As a corollary to this, and often they are read together, but they're two different attributes of any sort of corporate entity, is the issue of limited liability. And when we think of limited liability, we sometimes have a question of what do we mean by liability, to what extent is it limited, and so on. I will go into a little bit of detail about how the DAO Model Law approaches this question, because it's a very important one, especially given the sort of cases that have emerged in the past year with BZX, for instance, but also in other contexts, like with Tulip Trading and Craig Wright, with software developers' liability. So here we're mainly concerned with the liability that attaches to business organizations. Limited liability, despite its name, is always, to an extent, partial, because there's, even in a very strong limited liability case, there's always certain protections to prevent an entity being used for fraud. So here, our idea was that those who are contributors to a DAO, for instance, or participants in a DAO, should, as a corollary to legal personality, also have protection over their own assets compared to those of the entity itself. And so this separation that is achieved by legal personality and limited liability was again something that we saw as being relevant for DAOs as well. There's also questions that had begun to emerge then and have only increased since then in the last 5 years about taxation issues, about how do you tax a DAO? Do you treat it as a pass-through entity? Do you treat it as an entity that has its own tax obligations? There were a host of these issues that emerged beyond just issues of, for instance, crypto asset taxation. And of course, associated with all of this is the idea that DAOs need to have a certain predictability and certainty about their status, both for the benefit of its own participants and members, token holders, but also for the outside world who interact with DAOs. That could be within like a particular ecosystem, but it can also be in the wider world. This, of course, leads to the very obvious question, given that I mentioned some of these corporate entity attributes, which is why don't we just incorporate? And of course, if you look at, and those of you who are familiar with DAO regulation, you would be familiar with this already being an approach that is favored a bit in some jurisdictions. So the incorporation approach would basically run into certain obstacles in our view. One is that, as we know, DAOs are born global in a way because they are transnational entities with global operations that in some cases clash or defy the idea that entities are often forced into a patchwork of regulations because of different nation-state laws. But as these sort of born transnational organizations, the incorporation approach runs into certain boundaries, certain roadblocks that existing corporate laws are not always very pitched to deal with, even though, of course, as we know, with multinational companies and so on, there are ways of addressing this, but they're not necessarily fit for purpose in this case. DAOs are also pseudonymous, and that also raises issues, given that identifiability of certain individuals is a sort of assumption that exists in a lot of corporate laws. There is, of course, in some of the more advanced jurisdictions, ways in which LLCs, for instance, can be anonymized, but the default in most places is that there is a predisposition towards revealing the identity of certain people, and again, and not just identity, but also quite a few significant disclosures about them as well. So again, it doesn't necessarily mesh well with the idea of DAOs being pseudonymous. And DAOs are also autonomous in a particular sense, which is that there is a discrepancy between how DAOs are as entities as opposed to their on-chain incarnation. And as a consequence of this, tying a DAO to a legal entity can sometimes exacerbate this tension between what their on-chain activities are doing and what their off-chain legal entity is representing. And then a claim that is also made about this is that DAOs are already registered in a certain literal sense because they're, their activities are to an extent known through a secure, decentralized, and tamper-resistant ledger. And so a lot of what we try to achieve through registration and publicity in corporate laws and corporate law procedures is already starting to happen because of the nature of the technology that DAOs are using. And then there are sort of broader normative points as well. One of the ones being that through this process of incorporation, some community members feel that the DAO is no longer what they thought it was and that it doesn't seem like a DAO anymore to a community. In practice, we see some DAOs saying that the bureaucracy of even using an incorporated form like an LLC, a private limited company, etc., even some of the bespoke entities are not actually that easy in practice because the bureaucracy is very difficult to navigate. And in the view of like our assessment and ongoing assessment of some of the other DAO regulatory models that are emerging, no existing blockchain LLC model is able to actually deal with this issue of having like high administrative overheads and providing something that is a bit more lightweight. And so that was like our view and sort of cut of the incorporation option, which the DAO model law varies from. So then the question comes, and I'll try to go through this quickly. It might not be as interesting for those who are not lawyers or legal academics, of course, but it's a question of like, why would we talk about a model law in the first place? Model laws are very common when we talk about any sort of new type of like business or technological paradigm that emerges, and then people try to think of how do we grapple with these issues that are being raised by these developments. So the one is to give like this sort of prescriptive approach to this by saying that this is what we think should happen with respect to the governance or regulation of this particular space. But there's also clearly a normative function to this as well, where the certain types of precepts, or even in some cases ideologies, come through the model laws as well, where if, for instance, with corporate entity-related model laws, things like, you know, protecting minority shareholders is a principle that has a certain understanding of why minorities should be protected from majorities that is captured through a model law. Similarly, with using the same sort of example, model laws will often specify that these are the sorts of procedures that need to be completed for registration or to do disclosures on a regular basis so that the interests of shareholders and creditors are protected. And again, this is what is usually done with a model law as well. And the idea of why it's called a model is that instead of it being necessarily transposed word for word, the essence of it tries to be captured in legislation that national jurisdictions ultimately end up passing. And in this very like diverse range of jurisdictions that exist, that level of leeway has to remain so that it fits within the legal framework of each place. So we don't aspire to, for instance, create like a European regulation through this model law, because that would directly apply to member states because of the fact that there needs to be this leeway. At least that is the understanding with which we approach this. So turning to the model law itself, version 1.0 was released in 2021. We had several contributors who come from different legal backgrounds, from different jurisdictions, from different parts of continental Europe to the UK and the US, to even parts of the global south. So as I mentioned, I'm from Bangladesh, and we also have people from Iran and other places as well who can give a different perspective on this particular development. But also we had people who were contributing as developers. And again, I think as our approach to looking at the governance of DAOs is quite different, this balance of authors was very important to be able to achieve our objectives. So we had several inspirations for the model law. One is that the Organization of American States in the US developed a very simplified model of a stock corporation, where, for instance, it said that having a board of directors is optional. You can completely, through contract, design the governance of your entity and so on. And this was inspirational in the sense that the idea was that whether you're from a civil law jurisdiction in South America or a common law jurisdiction in North America, you would be able to still adopt this quite easily into your jurisdiction, and it would fit in quite a modular way into whatever legal system you have. But then we also looked at inspiration for two other instruments. One was the Hague Convention and the law applicable to trusts, and the recognition of these trusts. And this was very interesting because this instrument allows for states who sign on to it to recognize an entity that isn't created in their own jurisdiction and give them legal personality and legal effect. In particular, if, for instance, a civil law jurisdiction doesn't have its own trust laws, it still recognizes the activities of a trust that was constituted elsewhere. And we thought that's, again, very important, given the transnational nature of DAOs, to approach the development of this legislation in this way, so that it's able to receive broader recognition than just in the place where it's supposedly constituted. So this recognition approach would be one of the ways in which we try to achieve transnational acceptance. Similarly, the Untitled Model Law for electronic commerce is interesting because it's one of the first articulations of like a functional equivalence approach, which means that if you have a wet signature, so a written signature, it establishes the functional equivalent of that as an electronic signature. And we felt that if we are trying to do this functional equivalence of certain actions that are taken with a DAO with what a corporate entity is doing, then again we can look at this existing model law for inspiration. And so, as you can tell from what I've said so far, the principles that underlie the model law are of functional equivalence and regulatory equivalence. And that by using these principles and a DAO that, basically falls within the DAO model law would be able to meet very important policy objectives that usually undergird like a liberal democratic system. So as we know, and many of you who are here are familiar with, DAOs face significant legal uncertainty that can be detrimental to their development and utilization. And what the model law aims to provide is legal certainty without requiring the DAO to register as a legal entity in any jurisdiction under any national law. The idea of functional equivalence, as I've briefly explained, allows the establishment of equivalence between an object that is already within the realm of a legal rule and another object that is not yet encompassed by it. So the wet signature versus electronic signature analogy. Then you have the idea of regulatory equivalence, which relies on the same technique but identifies the object or purpose of any given regulation as a goal. So it allows the establishment of equivalence between the function of a legal rule and the function of a technology. So if we think of an example, there is regulatory equivalence between registration requirements for corporate entities and the deployment of a DAO on a permissionless blockchain. The deployment of a smart contract on a blockchain with relevant data about a DAO is not functionally equivalent to registration into a corporate registry, but the policy objectives of publicity and certainty are being achieved in the same manner. And so regulatory equivalence in a way tries for something a little bit even more ambitious than even functional equivalence, but it's still trying to meet these important policy objectives that usually undergird corporate laws. The model law adopts a principle-based approach to identifying what these policy objectives are. And again, we drew on our expertise of different jurisdictions to do this. It recognizes that DAOs are essentially transnational entities that can provide tech guarantees that are equivalent or even better in some cases to achieving these public policy imperatives than the protections that are now being offered by corporate laws through existing formalities and reporting requirements. The model law seeks to implement these objectives and principles by limiting its scope to DAOs that meet specific technical and governance standards, and by providing rules that these DAOs' technological features offer satisfactory protections and meet purposes in a manner that is equivalent to existing law. And so one of the sort of more law and economics type of ideas that we were grappling with is what is called like the principal agent problem between those who are agents of token holders within a DAO, and how to prevent the agent exploiting the principal. Also like majority-minority conflict, so the horizontal agency problem, as well as conflicts that might emerge between the let's say the DAO itself with the wider ecosystem and the wider world. So with the problem that can happen between a corporation and its stakeholders, for instance. And we hope, in terms of implementation, and at the end I will go to this, that if a state adopts or transposes the model law, an unregistered DAO that fulfills these requirements will have rights similar to other corporate entities in that jurisdiction. For instance, like an LLC does in a US state. So I'll briefly try to go through the different articles, and in the Q&A I'm very happy to go into detail about these articles. There are not that many. So the first article suggests that a DAO is a legal entity that can be used for a wide range of activities. This was important because we wanted to clarify, and even back then when we started working on this, that DAOs are not and will not be only used for commercial activities. That might be one approach, but like a club or like a society or a non-profit or something that is a hybrid of a for-profit or non-profit activity could be something that a DAO is used for. And so we wanted to clarify that there should be scope for recognizing this and not pigeonholing it into a particular type of for-profit or non-for-profit status. Article 2 bestows legal personality to DAOs that fall within the scope of the model law and suggests that DAOs' liabilities are met by all of their assets. So this is a very important provision because it deals with the legal personality issue that I mentioned. It allows the DAO to sue and be sued in its own name, to enter into contracts and so on. And the issue of meeting liabilities through their assets is to preempt concerns that might be raised that DAOs would be created fraudulently to sort of exploit the legal system. Now, of course, it's already very easy in advanced jurisdictions to create a company with a very low cost. And so we also mentioned this in the explanatory notes for each of these articles to say that there shouldn't be too onerous an obligation placed on DAOs either in this respect. That we already see, for instance, the gradual erosion or removal of minimum capital requirements, for instance, for companies. So it shouldn't be that DAOs are completely, forced into basically committing a large sum of money to protect themselves to get this benefit. But at the same time, we acknowledge that given the certain characteristics of DAOs, there might be concerns about exploitation of a DAO that has legal personality in certain socially harmful ways. And so after the legal personality provision, we have Article 3, where we go into important definitions of terms that we use throughout the model law, but also that are, I'm sure, very familiar to this group. So one that I wanted to highlight is one that's obviously contentious about what is a DAO at all. And in our case, we define it as smart contracts deployed on a public permissionless blockchain, which implements specific decision-making or governance rules, enabling a multiplicity of actors to coordinate themselves in a decentralized fashion. These governance rules must be technically, although not necessarily operationally, decentralized. To explain this second sentence a little bit, the idea being that we acknowledge that DAOs will end up having many different types of governance models reflected in how they operate. We felt that what was most important is that there should be a minimum level of technical decentralization, even if operationally in some cases they are not decentralized in the same way, in the sense that there might be a tendency towards concentration of power in certain hands that can happen, that can arise over time. Now, this was supposed to be a minimum definition. Of course, on top of this, we imagine the situation where and hope for where there will be like multi-stakeholder governance, for instance, within these DAOs. But we didn't want to be overly prescriptive because we felt that that would otherwise lead to the situation that a lot of DAOs that are legitimate and are operating legitimately end up being excluded because we placed very stringent thresholds for instance, how multi-stakeholder governance operates and so on. We wanted to strike this balance between being prescriptive and allowing flexibility. This is Article 4 is perhaps the heart of the model law, in the sense that it provides formation requirements that are functionally and regulatorily equivalent to the formation requirements of a company, but don't require the use of a legal entity and don't require registration. So there are 9 requirements that are mentioned here. So they basically require that the DAO is deployed on a permissionless blockchain, that it has a unique public address through which it can be contacted, that the software code is posted on a public forum, there's a quality assurance audit, there's a GUI that can be used to read key variables of the DAO. There is, as I mentioned, this technically decentralized governance system. This is all accompanied by a comprehensible plain language bylaw. There is a point of contact identified for the DAO, and that there is a dispute resolution mechanism for internal disputes that the DAO encounters. This last one comes especially not just from the fact that most entities have some type of dispute resolution mechanism mentioned, but also good practices that we know about maintaining commons, for instance, where Eleanor Ostrom identifies the need for a dispute resolution mechanism for the management of commons. So it's a very common feature that is required and is one that needs to be thought through carefully in the context of particular DAOs. The point of contact is important, for instance, because of service. And again, if the DAO is to contract in its own name, it still needs to be able to read, send and receive certain communications as well. And we provide some suggestions as well as some insight from emerging case law about how this is developing this particular issue of, for instance, service and communication of a DAO, but also because of the changes that are emerging with service being done through NFTs, for instance. Then we turn to, along with limited liability, the important point of legal personality, we turn to limited liability. So we specify that members will not be held liable for any obligations incurred by the DAO beyond their contributions. They only will be responsible in tort for wrongful acts, but they will not be personally liable for wrongful acts or omissions. The only cases in which we imagine there would be basically no limited liability would be if there is an evidence of fraud, for instance, and that's quite a common exception to limited liability. But we also provided a provision that if a DAO refuses to comply with an enforceable judgment, the members who voted against compliance will be liable for monetary payments ordered in the judgment in proportion to their share of governance rights in the DAO. And that's to, again, deal with this sort of situation, or to avoid this situation where there's an active effort to try to avoid enforcing judgments that have already reached that stage where there's a penalty being levied on the DAO. What we, again, we're thinking about is that a policymaker who would look at this model law would raise concerns about the abuse of limited liability. That these people are trying to use this as a shield from being personally liable. So again, we, instead of being prescriptive about one way of dealing with this, we say that DAOs over time could introduce requirements for DAO members to make financial contributions to a reserve fund or towards the premiums of an appropriate insurance policy for the benefit of limited liability. So there could be a way in which, through these privately ordered funds or premium payments, that this concern that limited liability would be abused would be avoided. And this veil-piercing option that's mentioned in 5.3 would also mitigate this risk of abuse, as it would basically provide that members can't simply refuse to pay a judgment. Again, note that Articles 5.1 and 3 does not make members liable for excess liability that the DAO is unable to pay from its assets, but only if there is an outright refusal by the DAO to respond to judgments that are made against it. So it's quite a limited carve-out relative to, and provides quite extensive protection for what we are calling participants and members of the DAO. So then Articles 6 and 15 that are part of Chapter 4 goes on into looking at how a DAO under the model law is to be governed. It seeks to allow DAOs to have flexibility in how their internal organization and procedures take place. For example, it doesn't require any in-person physical meetings, even if, of course, there's flexibility to have them, but it's not obligatory, unlike the case of many corporate forms. The model law enables management by consensus, as well as the appointment of administrators or directors or whatever, but it does not require DAOs to have administrators or directors. Again, it's trying to sort of remove a lot of the defaults and in some cases mandatory rules that exist in corporate laws with respect to this. The model law, of course, still recognizes that a DAO may need to have representation off-chain for certain purposes and activities. So what this chapter tries to do is provide a procedure for appointing a legal representative with narrowly defined powers that can interact with territorially bound jurisdictions in the spirit of contractual freedom. DAOs are permitted to appoint fiduciaries if they wish, but the model law makes clear that just holding a position with a particular title of a representative or administrator and having certain potentially discretionary decision-making powers should not be in itself sufficient to imply implicit fiduciary status. So this, in a way, complements a lot of what more progressive jurisdictions with LLCs try to do, where they provide the possibility of the operating agreement excluding certain types of fiduciary duties being imposed on leaders of that organization or members of that LLC. And so we are trying to reflect this, that there shouldn't be this implicit fiduciary status imposed on someone just because they have a particular title. And we think that this is a very important provision, especially in light of recent cases where there's this characterization of certain DAOs as being partnerships or associations, and this sort of implicit fiduciary duties are starting to be construed because of certain actions they took or certain positions they hold. We believe that there should be that this shouldn't happen implicitly, but in the operations of these organizations. So then, Chapter 5 starts looking at technical features that DAOs have that raise new questions that merit specific treatment. So what this chapter tries to do is have specific articles that concern the consequences of contentious forks, modifications, upgrades, and migrations on the legal personality of a DAO, as well as its claims and assets and the limited liability of its members. So it provides, like in Article 16, that if there is a hard fork, what happens to the assets of the DAO? So the default will be that the majority chain and any off-chain assets will belong to the DAO in the majority chain. Article 17 then provides requirements for a DAO to retain the benefits under the model law, even if there's a migration or upgrade and modification that happens, so that the on-chain activities don't end up having a negative effect on the off-chain recognition of that entity. Article 18, and I'm almost done going through these provisions. Article 18 goes into more detail with respect to failure events that are specific to DAOs. So, and what could happen to legal personality and limited liability in particular if a failure event happens. And what this article suggests is that legal personality and limited liability are maintained to the extent necessary to protect DAO members and participants from being personally liable, so that there isn't a break in limited liability and legal personality, unless, again, the persons deploying or operating the DAO acted in manifest bad faith or engaged in gross negligence, so that they would end up becoming personally liable because of this sort of mental state in which they acted to do this, and the clearly grossly negligent nature of that action. Again, that would be something that would have to be proven ex post. Then Article 19 and 20, the last two articles, specify when only lacuna in the bylaws, they're basically general provisions. Article 19 talks about lacuna in the bylaws and the model law that have to be filled because there's something that happened that doesn't fit within, let's say, the bylaws of the DAO or the constitution of the DAO, or in this model law. Then we need to refer to a general business organization law. And we say that in this order of priority, it should be very low compared to the others and shouldn't be referred to. Article 20 is the sole taxation-related article in this model law, and it basically makes DAOs as a pass-through entity for tax purposes, so that members and participants are the ones responsible for tax compliance. And one of the things we say with Article 19, if there are concerns that this reference to general business organization laws could be against the intent of the founders or members of the DAO, we say that if this law is referred to for a gap-filling purpose, it should be resolved in a manner that upholds the objectives and letter of the model law. So it shouldn't be that basically that the entity is suddenly turned or treated as a corporation or a variation of a corporation just because it seems more convenient to the judge. So having now gone through the provisions, I will end the presentation by talking a little bit about the different models that already exist and where the model law is starting to gain some traction. So we know that there are these incorporated DAO models in Vermont, Wyoming, Marshall Islands. The BBLLC that was used by DORG is one that, for instance, used Vermont. We also have started to see, reform efforts that try to introduce DAO legislation in Australia. There's this discussion happening in the UK about DAO legislation in St. Helena and in New Hampshire. All of these also mention the model law in the deliberations that they're currently having, including in the New Hampshire legislature. Utah, the state of Utah, is the first to actually adopt to a large extent the DAO model law as its basis for regulating unregistered DAOs. Through the Utah DAO Act, there's a Forbes article about this that I'm happy to share with you that again goes into a little bit of detail about the process behind it. To a large extent, it even adopts the terminology and even the wording of the DAO model law, but there are certain important differences which I'd like to highlight. And in the questions, I'd be really happy to talk about is that what are the sticking points that lawmakers who looked at this piece of legislation were not happy about, that they felt that no, this doesn't serve our policy interest. We want something different to be included in this law when it's introduced into our state. So one was that even though this law doesn't require registration, a DAO that has not registered as a for-profit corporate entity or a non-profit entity to be treated as the legal equivalent of a domestic LLC, it still requires the presence of a registered agent in Utah. And the idea then is that the idea of having a non-territorial contact person in the formation requirements was not enough. They wanted someone who is in Utah. It could be a law firm, it could be someone who's not really in the DAO, but there needed to be a person that they could reach in Utah. And this came out through the debates that happened on the floor of the of the legislatures of Utah. So why, to have the last word on this, why is it that we need to have this model law approach, and why would we continue to develop this? So as I said at the beginning, a lot of unregistered DAOs face a lot of legal uncertainty. They face issues with legal recognition of their actions. What we're trying to do through this approach is to act as an incentive for DAOs to start, quote unquote, voluntarily complying with existing rules and public policy imperatives to get certain benefits like legal recognition, legal personhood, and limited liability. So instead of taking the stick approach to legal enforcement, we take more of a carrot approach. But conversely, we hope that the lessons we are learning through this of regulatory equivalence, that we find new ways through using technologies to be able to achieve certain regulatory objectives. And this could be something that is significant for more than just DAOs. It's something that could be existed by existing institutions in trying to not introduce new legislation, but in some cases using technology in different ways to achieve public policy imperatives. As this has been a couple of years now, and we're starting to see some momentum with the model law, we also noticed that there are certain aspects of the model law that are starting to look a bit dated and need updating because of the realities of how the space is evolving. So we've created a few working groups to try to work towards DAO Model Law 2.0. One is to continue refining our sections on identity and limited liability. The other is to deal with issues of privacy and transparency. The third, and this might not even in the end be in the model law itself, it could become a separate document, is to continue working on taxation and learn lessons from those who have a lot of experience practically of the taxation of DAOs, to learn about model treatment for DAOs that is desirable for the wider community, and finally to continue developing technical guarantees that achieve functional and regulatory equivalence in the way that I just mentioned, so that it can be used even in context beyond just DAOs. And we hope that in this process we'll also introduce some updates which make the DAO model law a little less Ethereum focused, but something that is applicable for, and is basically more blockchain neutral. So thank you very much. If you have any questions, I'm very happy to hear them now. Thank you.
Right. Well, Morshed, thank you very much. That was just fantastic. You've taken us on a bit of a crash course there. Obviously, the DAO model law text itself is very dense, and for anyone who is reading it for the first time, it can be quite technical and hard to understand. So I think you've done really, really well in sort of summarizing the key aspects of it and what it means. However, we have several founders and core contributors from about 10 DAOs here, and I would like to invite all of them now for a Q&A session. I think first of all, Lana, a while back you said, can you talk more about 4 and 5? So Lana, if you're there, just take yourself off mute and give us a little bit more context. Are you talking about the slides or the chapters?
Yeah, so that was on slide 10, I believe. Okay. And I mean, honestly, like you said, this is very dense. And for me, I'm just looking for something practical here that I can, take away and use immediately. Sure. Thank you. I appreciate it. But I absolutely, like the lingo, the law is not, it's very unfamiliar to me. So I'm looking for something, like practical that I can, using the DAO to grab onto. And I was looking at slide 10, and these all make sense to me, except for I'd like to know more about the quality assurance audit and then the GUI.
Great. This is exactly, in a way, the sort of question we were hoping for, because in a way, as we knew even when working on this, the legislative process for this DAO model law to be used and so on is much slower than what could actually happen in within the DAO ecosystem or in general, where things could move a bit faster. And so what we would hope to do is that we would end up having certain DAOs that go towards fulfilling basically these formation requirements and while knowing that there will be several who don't follow all of these formation requirements either. So to look at 4 and 5, which are the quality assurance audit and at least one GUI to read key variables, this was supposed to meet certain objectives about the idea that if you do not have the software, if you have failure events that are occurring because the software doesn't operate in the way that you expect it to, then you end up having the type of problem that we anticipate in, Article 18, which is this one, Article 18. And that it could lead to the issue that you end up having a break in what, let's say something about the DAO malfunctions, and you end up having a break between the legal entity acting or being recognized as a legal entity and with the actual on-chain interactions of it. So usually this problem will not happen with a normal legal form because of the fact that there isn't this merging of the legal registration infrastructure with the entity itself. Given that this is happening here, there needs to be this assurance, not just for the avoidance of these sorts of failure events happening, but also to give confidence to the wider ecosystem that is interacting with it, that this the way that this DAO is operating is the way that we anticipate, that the way that it is described in, for instance, the bylaws and in other documentation. Relatedly, again, one of the core things that we found while working on this is about the importance of publicity for corporate laws. So a lot of the reasons why there is all of these disclosure requirements for most types of entities, sensitive ones like charities and so on have even more disclosure requirements, is because they want to give publicity and transparency to not just those who are interacting with that entity, but also a wider public. And that should be available to anyone fairly easily. And again, that is why in number 5 we talk about there being a GUI through which it's quite easy to find certain information about the DAO. Now, those key variables could be something as simple as where they can find the bylaws and who the point of contact is, but a DAO can also go further than this and provide more variables that help create this meeting this publicity requirement, while of course acknowledging that there could be a very good reason why the DAO feels that there are certain things that it isn't able to disclose or that it doesn't make sense for it to disclose.
Excellent. Thank you, Morshed. I'm just looking at the questions here again from Alessio from Hypernest. He says, amazing presentation. How can we make sure that the model law applies to our DAO? I might have missed it. So, Morshed, it would just be good if you can just sort of touch on that very briefly. Where does it apply? Where doesn't it apply? How should DAO founders who have not done anything with regards to incorporation legislation or sort of getting set up, how should they be thinking about this to make sure that they are in alignment with those requirements?
So very simply, our idea is, with the model law itself, that if you meet these 4 formation requirements, you get all of the benefits that are mentioned in the model law. It's not just these, it's in more detail, of course, in the actual text than it is here.
Sure.
But once you meet these requirements, you should be able to be recognized. Now, that's what we aspire to do. Now, what I would actually say is that if you want to understand practically how this is being implemented, I'd recommend looking at this Utah DAO Act, and after this I'll give a link to it. There it has this formation requirements, and that tells you that if you meet those requirements, you would be recognized as the equivalent of a domestic LLC in Utah. Now, the work that we have to do, like COALA, but also our friends here and elsewhere, is to try to have this, adopted in more jurisdictions, so that this actually is not only in Utah that you're recognized as the equivalent of a domestic LLC, but in more places.
Okay, yeah, that makes a lot of sense. So, okay, Morshed, you said you will share the link to the Utah DAO Act, right? Is that okay? That would be great, so that we can just dive into that a little bit deeper. Steve,
just add to that. The Utah DAO Act comes into force, I think, in January 2024.
Okay.
So it's already adopted, but it actually has legal effect from January 2024.
Right.
The New Hampshire one is also very similar as of now, but it hasn't been passed yet, so that's why I haven't mentioned it. But that's also something to look out for.
Right. Okay. Fantastic. Thank you. Okay. I see here Steve. Steve is just about to leave, but he dropped a question in here saying, I think of DAOs as a continuum where you can just use DAO tools to organize a casual group all the way to a major token offering with significant financial obligations, employees, etc. So what tests can we apply as the organization grows to know when we have more legal obligations or exposure? So I guess, are there specific types of triggers that would require you to fulfill these requirements? Is there sort of a boundary, Morshed, or again, does it depend on very different circumstances?
This is a really good question. I think, as I mentioned at the very beginning, when I talked about, I'll bring it up again, like what are the activities that they could do? Right now. Yeah. So at the outset, of course, we envisioned that the DAO would be doing many different activities, and as you said, it could be even a continuum, that it starts doing something and changes. I can imagine that those DAOs which don't have a lot of interactions with off-chain entities, that are not do not deal with a lot of high-value transactions, that are more like a club of a certain sort, might be able to, it wouldn't need any of this at all, because of the fact that it sort of doesn't encounter these sorts of issues. This becomes relevant, I think, in the context where there is a concern that individuals could become held personally liable, that they need to enter into a lot of on-chain transactions, and that there is relatedly a concern that, off-chain transactions, and there is a concern that people could become construed as being fiduciaries of these complex organizations that are entering into high-value financial transactions and lead to personal costs for them. If that doesn't sound like what you're doing, then of course this is not as relevant.
Right, perfect. I hope that answers your question, Steve. Folks, I'm just mindful of the time, especially all of you over in the US who might have a call or another meeting starting right now. So I'm also just trying to be respectful of Morshed's time here, and I don't want to overrun too much. So I just want to check finally any more questions. No, we've got just lots of great comments from Paige saying great presentation, certainly aspirational. Steve saying thank you, and Alessio. So Morshed, I think we're going to stop there. Unless someone has a burning question, one final question. Anyone? I see Jim is typing. It might just, no, he says, okay, just thanks. Okay, so.
I have one real quick one.
Please. Yeah, go for it, Kyle.
Yeah. In the Wyoming Senate chat or whatever, I put it in the comments in more detail. What is it? Let me look it up real quick, the name of the committee. The Wyoming Select Committee on Blockchain and Financial Technology and Digital Innovation Technology. David Kerr, he said that since Utah adopted COALA, which is fantastic, that's amazing news. But anyway, he says that it has brought in civil law concepts of liability, and then it's going to be a headache for Utah down the road in litigation. So I'm just wondering if you agree with that comment or not. Just a really quick thing. Hopefully you can.
I think I feel like what is going to most likely happen is that as we are starting to go through the first serious wave of actual litigation of DAOs, like everywhere in the US, but also in other places, I think we will know more about what these particular civil liability risks are. And that will affect not just whether there needs to be, let's say, an amendment of the Utah DAO Act, but also, as I said, like, as we're now trying to update the DAO Model Law itself, we're using these cases as a way of trying to better understand the risks that are emerging as well. And part of it could be this issue of like the conflict between civil liability and like civil law liability and common and the common law down the road. But because this is also starting to happen in Europe as well, where we're starting having conversations about what would a model DAO regulation look like for Europe, given that they're both common law and civil law jurisdictions, and there's quite a bit of variety there as well as different conceptions of what these different liability regimes would look like. So in a way, I don't think there is like one. I can't really like predict the future about what that litigation would look like, but we would definitely, try to make sure that we can keep the Act and the model law up to date so that it's able to deal with these tensions and try to reconcile them.
Thank you. That was great.
That's brilliant. Okay, folks, I think we're going to stop it there. Morshed, I just want to thank you again so much for being here today, sharing all of this work with us and with DAO Club. You are doing great work, so please keep doing it because it's so important. And on behalf of everyone else in cohort 4 and in the rest of DAO Club, I just want to say thank you, and we appreciate the work that you're doing. So that's it, Morshed. Any last comments from you before we go, Morshed?
No, thank you very much for this opportunity. If you'd like to connect with me on Discord or Twitter, I shared my handle here. It would be great to get in touch and to learn more about your work as well, which we weren't able to talk about today. But I'm always excited to meet and speak to DAO founders and leaders and developers.
Absolutely, thank you. Yeah, right. So you've just dropped your. That's your Twitter handle, is it?
Yeah. Yeah.
Fantastic. Right, we'll give you a follow there as well. Okay, folks, thank you for being here. To all the DAO Club members, really appreciate you turning up for yet another excellent event. I will see you next week, same time, same place. Have a great day, and thank you very much for being here. Bye-bye. Take care.
Bye.